Hello, everyone. Welcome to the AIA Contract Documents webinar on the No-Go 9 uninsurable contract clauses and how to respond. Just a quick disclaimer to get us started that none of the content we go over today should be acted upon as legal advice. If you have any issue that requires legal attention, we encourage you to just reach out to a local attorney. Another disclaimer that the presentation is protected by copyright laws, and that just pertains to reproduction, distribution, and display, because again, you will be receiving these slides. So with that, I'll go ahead and hand it over to our presenters for the day, who are going to take you through the presentation. So I'll pass it over to Andrew, Nancy, and Jimmy to introduce themselves and take you through the real content.
Thanks, Sydney. Nancy, why don't you go first and introduce yourself to everybody?
Good afternoon, everyone. It really is an honor and my pleasure to be here before you with this webinar. I've been an attorney for 30 plus years, and I went in-house with a professional liability insurance company some years ago. I handle the high-profile large loss claims against architects and engineers, and I do a lot of contract negotiations. So during that experience with contract negotiations, I've been able to identify a number of clauses that come up frequently, and we found that explaining to the owner, anticipating the response, and having a way to get back to the owner with a fair and uninsurable and an insurable clause is something that works well. Andy?
Thanks, Nancy and Jimmy, and also great to be here with you today. Andy Mendelson, I'm a licensed architect. I have been for over 40 years now. I practiced in the large firm environment for over 36 years in a variety of positions, as a designer, project manager, head of our company's education facilities market, and then as a managing principal in charge of legal and risk management issues, and as a CFO. My firm was called OWP&P in Chicago, and we merged into Canon Design in 2009, and I was director of practice management for Canon for about 4 years before I joined Berkeley Design Professional as a chief risk management officer. So we offer risk management education from the practitioner's perspective. I spent 15 years on AIA Documents Committee from 2003 to 2017. And so I have a lot of contract knowledge from that experience, as well as just in practice and the consultation we provide to our clients as well. So thanks for having me here today.
Awesome. Thanks, Andy. Thanks, Nancy. Thanks for being here. Just real quick, I'll be your moderator today. My name is Jimmy Germano. I'm an attorney working with the AIA Contract Documents program. In that position, I work with the AIA Contract Documents Committee, like Andy mentioned, to update the contracts on the usual 10-year cycle. Some of them we're going to talk about today a little bit, but most of them we're not. At the end, if we have time, I might go over just a little bit of an outline of the Contract Documents program, but I want to make sure that we get into the substance of why you are all here today attending this, what I hope to be a really informative and interesting webinar. Just real quick about me, I'm a construction litigator from the DC area and litigated for 7 or 8 years before coming over to the AIA, and in that regard represented a lot of owners, contractors, subcontractors, some architects, developers, suppliers, pretty much everyone up and down the chain, litigation, mediation, arbitration, and contract negotiations. So with that, let's talk a little bit about what we're going to do today. So the objectives today are fivefold. So we're going to analyze 9 commonly proposed uninsurable clauses, and we're going to have a little bit of a sort of a rapid fire, going back and forth between Nancy and Andy and what they think about clauses and where the clauses come from, how to negotiate them, things to edit. So I'm very excited about that portion. We're going to review insurance coverage problems. We're going to suggest alternative language that the client, that your client might accept. And we're going to discuss arguments that the client might raise. And then lastly, offer talking points for the architect to use in response. and a little bit sort of a picture, a diagram showing what we're going to do today and how we're going to do it. And to explain a little bit about the genesis behind this slide, I'll hand the mic over to Nancy and maybe explain a little bit about what the audience is looking at here and how they can use this to understand today's presentation.
We just put a few examples up as to what you might expect to hear when you give some pushback to a client, explaining that you can't agree to a particular clause because it's unfair or it's uninsurable. And you start to hear the same responses from owners many times. But everybody looks to insurance when things go bad. And especially parties on a construction project will want insurance. And when you think about the time and effort that the owner puts in the owner-architect agreement, designating what kind of policies of insurance the architect is supposed to have and what the minimum insurance requirements are, you know that the owner wants insurance coverage. So I find that with a little bit of education to the owner, explaining to the owner why a particular clause is unfair because it's not insurable, and then offering to the owner a way to meet the objective but to make the clause insurable, will actually get to a meeting of the minds and come up with a clause that both parties can live with. When you take the time to do it, it pays off. And so I think we can go on to the next slide.
Sure. So the first topic we're going to talk about today is a common one that I'm sure all of our attendees deal with a lot, and that is the initial project information. So I think Andy's going to take this one. So Andy, why don't you tell us a little bit about initial project information and why it might be a little bit of a pain point during negotiations?
Well, we feel that it's really important to have a clear description of the project, nature, parameters, and key criteria. And that's what's embodied in Article 1 of the AIA 101. We put a lot of effort into this in 2007 and then again in 2017. In fact, in 2007, initial project information was an exhibit to the owner-architect agreement, and we learned that a lot of architects were finalizing their contracts without including that exhibit. Without this information, it makes it very difficult to manage the business issues of the project. So Nancy talked about a meeting of minds, and it's very important that people start out, you and the owner, as to what as an example, what is the owner's program? Functional, spatial, technical. What is the site information? What's the project schedule, including any design phase milestones that might exist or be known at the time. Very importantly, the project budget and the construction budget, project team members, the architect's consultants, the owner's consultants. What about the construction delivery method? Is it design, bid, build, or is it one of the construction management forms or design, build? And of course, AI has specific forms for those types of delivery methods. But one of the things that's important to control is if it's a multi-phase project or requiring multiple bid packages, which are very expensive for the architect and your engineering consultants to prepare. The more there are, the more costly it is to you. Also very important in today's day and age is the sustainable project goal, if there are any. And if so, we recommend you use the E204-2017, which defines the roles of the owner, architect, and contractor for sustainable projects. So again, it's important that everybody be on the same page. This is initial project information is the basis of your agreement. We don't want to see you refer, vague discussions that may have occurred as you were interviewing for the project. Sometimes it's even a problem to refer to the RFP because some of the criteria may have changed as you've negotiated the contract. So if your owner-architect agreement is not an AIA agreement, make sure you include this same information as we're showing here on the right side, the beginning of the initial information section. Make sure you include it in your contract. Very important.
Awesome. Thanks, Andy. So I think that's a really, you know, obviously critical piece of information to include is filling in this Article 1, the fill point, attaching a separate exhibit, however you want to do it, but making sure you hit those key points. And that sort of dovetails into what our second topic is, and that's, you know, when an architect is generating this initial information and basing their agreement upon the information, they rely upon some information, to use that word like 10 times, from the owner. So that's actually our second topic. So there is a right to rely on information provided by the owner, usually set forth within the agreement language itself. So Nancy, why don't you talk to the attendees a little bit about this right to rely on the information provided by the owner?
Thanks, Jimmy. Yes, in the B101, the architect has the right to rely on the accuracy and completeness of information that's provided by the owner. And it's really important, especially with the geotechnical engineering investigation that traditionally the owner is expected to provide. But there are some ways that the owner makes inroads into this right to rely on the information provided by the owner. I've seen where the owner is asking the architect to visit the site and make a comprehensive inspection to verify that the information is correct. And I think you have to push back on that. Well, not just think that you have to push back on it. You can't let go of that right to rely on the completeness and accuracy. You don't want to alleviate the owner's obligation to verify the field conditions. You can notify the owner, and I think we can go to the next slide on this. Jimmy, there we go. No, I'm sorry, we didn't have that. Go back, Jimmy. I'm sorry. You can notify the owner if you become aware just by observing an inconsistency or an error in the information that's provided by the owner, but don't take on the affirmative burden of double checking and making sure that everything is right. You have that right, and you shouldn't allow the owner to make inroads into it. Okay, now go on to the next one. Sorry about that.
Oh, no problem. I thought
you were highlighting that last sentence there.
Well, it is an important sentence, and it definitely should be highlighted for sure. And that does sort of make its way into the next topic, which we previewed for everybody, and that is the standard of care. So you're now through the initial information stage. Maybe you're through those negotiations. You are now performing services, perhaps your initial stages of design development or something like that. And you have to perform those services at a certain level. So Andy, why don't you talk to us a little bit about the architect's standard of care?
Another topic that's near and dear to my heart, because the 2007 documents really put the first affirmative standard of care into an AIA agreement. As Nancy can explain if we have time, I mean, the standard of care exists in common law, and if you're so unfortunate to have a claim go to a judge or a mediator or arbitrator, they're going to define what the rules are. But what it is that standard of care is not perfection. You're a professional service provider. You're going to provide services consistent with professional skill and care. It's usually provided by others practicing in your same or similar locality under the same or similar circumstances. And we do see owners trying to elevate this occasionally. But when you think about that first sentence and you think about the types of projects that you are designing, you're going to be held to that standard of those doing those similar types of projects. I spent a lot of my career doing, K through 12 public schools, and we had significant expertise in that. As our firm grew, we expanded into healthcare and then higher education and then research labs and things like that as our firm got large. Well, we needed to make sure that we had that expertise to perform those projects in accordance with the standard of care. So if you're doing a hospital project, make sure you have the qualifications to do that, because that's who you're going to be compared to. Those larger firms that are skilled in doing that type of project. So it's certainly a good enough standard. So the standard of care is really foundational to negotiation of claims, because what happens is you're going to be challenged, did you provide your services in accordance with that standard of care? And that's where project documentation comes into play, as well as schedule performance. And this second sentence that says you're going to perform your services expeditiously, as is consistent with professional skill and care, and the orderly progress of the project. And that last phrase is important, because you're not in control of the progress of the project in all regards. You can be in control of what you do as long as the owner is performing, and of course, once construction has started, the contractor is really the important party. So a lot of times we'll see language such as quote unquote time is of the essence, which creates like an uninsurable warranty. And we don't want to see that. We want to tie our performance, as it states here, to this orderly progress of the project and the standard of care.
Mhm.
So go ahead, Nancy.
Oh, yes, before you go on to the next slide, I just wanted to point in that this 2.2 articulation of the standard of care is really a beautiful thing here, because it reflects what most states have identified, not in statutes, but in the model civil jury charges. So when a case goes to trial, the judge is the individual who decides the law. The jury is made up of people who decide the facts. And the judge explains to the jury what the law is and recites to the jury the model civil jury charges, which is very similar in most jurisdictions to this articulation here in paragraph 2.2. So it's really important that you articulate a standard of care that's consistent with what the law requires in your jurisdiction.
You could also reinforce the standard of care to have an express disclaimer of warranty and guarantee, an express disclaimer of fiduciary duty, and Nancy will be addressing these a little bit later. We think that's actually very important if you're doing a design build project, because the design builder, if you're a contractor leading the design build team, they are under a warranty standard, and they're going to try to pass through their responsibilities, and you cannot accept that as a design professional. So we think express disclaimer of warranty and guarantee is a good supplement to this clause.
So Andy, this is an appropriate standard of care, and I really like how both you and Nancy really explained the genesis behind the need for language like this. Can you talk a little bit about maybe what an inappropriate standard of care would look like?
Sure. And I've forgotten if we have a slide on there. There it is. I'm actually going to let Nancy take this one, because this is truly an area where she has more experience.
Sure.
Yeah, we see this once in a while, and actually we had to try a case where we were worried that if the judge interpreted this as the true fiduciary obligation that it would impose on the architect, then the standard of care would essentially be perfection and would not be consistent with the traditional standard of care expected of an architect. I've seen in some owner-generated contracts this new articulation of the standard of care. You know, when you look at, trust and confidence, and you think of something really good, like it promotes like a harmonious relationship between the parties, but that's not what appears here. This is the trust and confidence, the highest standard that's consistent with a fiduciary. These would be appropriate standards of care for financial advisors, for bankers, for executors of estates, for administrators of pensions, people who have control over other people's money. And this is not the appropriate articulation of standard of care for an architect. So even though it's a little bit misleading, like, yeah, everybody wants this harmonious relationship. Everybody wants this trust and confidence. This is a veiled indication that the standard is going to be higher. Fortunately, in that case that we had, the judge looked through it and imposed the traditional standard of care on the architect. But there was a lot of hand-wringing during that time where the judge heard argument on that standard, went back to the chambers and drafted an opinion, and we were really worried as to what was going to happen. So stem it at the beginning. When you see this clause in your contract, change it and put the appropriate standard of care in there.
And that is fantastic advice. I really like the real world example for sure to hammer that idea home.
It was hand-wringing.
I can imagine.
We were so worried.
So let's just say we're on this 9-topic track now. So we're through topic 3, the standard of care. We've gotten that down, and now we're going to focus on the architect's scope of services, right? So they understand maybe the level to which they have to perform services, but now they need to discover and really negotiate and figure out the scope of those services. So Andy, why don't you talk a little bit about scope of services, if you would?
Jimmy, the scope of services, again, is critical to be defined as clearly as you can. It really forms, again, the basis of the relationship you have with the owner in terms of the services you're going to provide for the fees that you have negotiated. So we have basic services, which are defined in Article 3 across the various phases of the project in B101. And basic services include architecture, of course, but only normal and customary structural, mechanical, electrical, and plumbing engineering services. We did a lot of work again in 2007 and 2017 to try to put a fence around what basic services are, so that architects can have a contract that helps them again manage the financial aspects of the project. What we did in 2017 is introduce the concept of supplemental services, which is directly related to additional services. And we're showing an image of Article 4 on the right side of the slide here. What a supplemental service is those that go beyond the basic services, such as civil engineering and landscape architecture, the programming aspect. Maybe the owner didn't provide a program, so you have to do a program. Maybe there's LEED certification. Maybe you've agreed to do as-constructed record drawings, things like that go beyond what Article 3 defines as basic services. But you know that at the time you're negotiating the agreement. And this was very important because many times your services that you agree to as far as the base contract do go beyond the normal basic services. So we call those supplemental services, those that are known at the time you negotiate the contract. Additional services are those that come up after you've negotiated the contract. Say, halfway through the project, the owner decides they want you to take on civil engineering or landscape architecture or any one of these other services that is defined in this table. And then what you also want to be clear on is the services you will not perform and that should be performed by others. Nancy mentioned earlier owner's information such as geotechnical information. Another important piece of owner information is the property survey and topographical survey. We recommend that those remain with the owner and that those be defined accordingly. So when you look at this chart on Article 4, and again, we tried to simplify it somewhat in 2017, we recommend that you fill out every one of those rows where it says responsibility as either you as the architect, the owner, or not provided. That way, at the beginning of the project, you've got a clear understanding, and similar to that initial information that we talked about, material changes to that enables an adjustment of schedule and compensation for the architect. You still need to notify the owner. You need to get their authorization to proceed on an additional service before you perform it. You're going to see that in any type of contract, including an AIA agreement. When you put yourself in the owner's shoes, you can understand they have your budget and your schedule to maintain. So they need to know about these things. They need to approve them before you go ahead and do them. So let's be as clear as you can with the services that you are providing.
Andy, I just thought of an example where I had an architect who did a project with the municipality, and unfortunately a claim came about on that project. And the architect was very astute in identifying specifically the design services that he was going to provide to the municipality, but then, and also specifically excluded any construction phase services. But then he added this little catch-all at the end that was open-ended, saying, and any other services to promote the owner's objective on this project. And so, of course, during litigation, all of the parties were pointing to that catch-all because the crux of the claim dealt with a construction issue, and everybody was arguing that yes, you could have done more, you could have actually come back to the site, and using that little catch-all opened up that finite group that the architect had so astutely identified and the parties had agreed to, but that was just like everything else could go into it now.
Now, I'll echo your experience. We have seen numerous claims from unclear scope of services during the construction phase, particularly when maybe your basic services agreement included normal services, and then somewhere along the line, it was decided that the owner did not want you to provide those services, and the architect and owner did not execute a proper contract modification. So, great points you're making there, Nancy. You know, in Article 3, again, having worked on these contracts for so long, you know, really every word matters, and particularly that section on construction administration phase services is really important. And I get really anxious when I see changes to the AI language there, because I know those words matter, and subtle shifts in words can increase an architect's responsibility, push it into that uninsurable category, and you really need to be careful about modifications, particularly in that section.
Yeah, I can see both sides, because the architect wants to really be like a security blanket to the client and say, look, if you need something else, I'm here, I can do it. But the way that it was phrased and inserted into the contract, every other project participant interpreted it a different way, and each one interpreted it against the architect.
I actually have we have a question that's come in, and I think it's appropriate maybe to throw it out there now and see on this topic sort of, and see what each of you think about it. So the question is, it deals with like government entities, right? So you have a government agency, you know, a city, locality, federal government, whatever it is, and there's an RFP that attaches a sample form agreement with terms and conditions, you know, as part of the RFP, and at least the indication made at the time of the RFP, you know, request is these terms are firm and non-negotiable.
Right.
So, and I would imagine that's relatively common. So, Andy and Nancy, do you have any just sort of practical advice, and you know, how should an architect be thinking about responding to the RFP in those kinds of situations? That's a great question.
Yeah, perfect question. Yes. I'll go first if you don't mind. I hear that a lot, and especially with an added sentence from the owner saying, if your RFP is going to be your response to the RFP is going to be rejected if you can't accept and embrace all the terms in this proposed agreement. But the key is you want to point out to the owner that like these particular paragraphs are, I can't agree to it and they're not insurable. So the owner really has to give pause saying, do I really want to push back hard on this? Because really, maybe there's something to it. If there's not insurance for these, maybe I'm not getting what I really want to have with the objective here. And so I say that, you know, right from the beginning, if the owner is going to be insisting on an unfair contract.
Yeah, I agree, Nancy, and we have like a standard. We had a standard sentence that we would use in our marketing responses about, you know, we've reviewed your agreement. If we're selected for this project, we would like the opportunity to review the terms and conditions so that they are consistent with our coverage under professional liability insurance. You know, the other strategy that's related to that is, you know, is a public owner really going to go through the whole process of shortlisting and then selecting you and then not going ahead and negotiating a contract with you because of uninsurable clauses? Most owners don't want to go back through the process again to do that. So, you know, I think when you see an RFP that has that absolute statement, you do need to issue some type of sentence. I mean, earlier on when I was doing contracts for my company, you know, they wanted us, the owners wanted to go through in detail and tell them what, you know, we objected to. And when if you give them a list of 20 things that you object to, well, that's probably going to knock you off of the short list. But if you have a simple sentence that gives you the right to at least talk to them about it, you know, that's a great start. And, you know, it's difficult to attain a perfect contract. Sometimes firms make decisions to take on risk that may or may not be insurable. Thankfully, across the country, there are a number of anti-indemnity statutes that have been adopted, and we're going to be talking about indemnity in a minute here. In fact, I learned about 2 weeks ago that Alabama is the most recent state to go ahead with that. And I don't know how many states have it, but there's been enough outcry by the state AIA chapters and our compatriots on the engineering side, ACEC, to work at the governmental level and try to get these uninsurable, at least indemnities, against public policy and basically not enforceable at the state law legislative level. And there's been a pretty good amount of success with that.
And that's a great point. It sort of highlights the negotiating tactics that have to go involved, because you want the work. Obviously, you wouldn't be bidding on it if you didn't, but you also don't want to take on unnecessary risks. So it's those are great things to consider for sure. And Andy,
a really good.
Go ahead.
Sorry, that was a really good question.
Yeah, I totally agree. And Andy, your comment actually leads nicely into topic number 5, which happens to be indemnity defense obligations.
All right.
Nancy, do you want to take this one? Let's talk about indemnities.
Yes. Many times an owner will take an indemnification clause that might be appropriate for a construction contractor and put it in the proposed agreement with the architect. And no surprise that indemnification will attempt to impose on the architect not only indemnification, but a defense obligation. So what's the problem with a defense obligation? Well, you know that your professional liability policy of insurance cannot be endorsed to identify the owner or any other parties as additional insureds on your PL policy. And the reason for that is that the owner is not an architect providing professional services for the benefit of your firm. That's the policy definition, the traditional policy definition for insured. So an owner can never qualify as an insured on your policy and can never be named as an additional insured. it's different for your commercial general liability policy and your auto policy, but for your professional liability policy, and this is what we're focused on now, you can't name the owner as an additional insured. So you can never agree to provide a defense obligation upfront to the owner in your indemnification clause. There might be opportunity later to agree to reimburse the owner for reasonable attorney's fees that are caused by the owner having to defend a third-party claim that turns out to have been caused by the architect's negligence. But at the outset, when you're presented with an indemnification, such as what you see on the slide here, you've got to start some editing and describing to the owner why this is not possible for you to undertake. So first and foremost, strike the word defense. You're not going to provide the defense obligation, but you also need to delete the predetermination nouns, and those are things such as liabilities, causes of actions, demands, claims, things that could trigger the indemnification as soon as a claim is made against the owner. So here what I've done, and they're highlighted here, the claims, liabilities, demands, causes of actions, allegations, anything that comes before there's been a determination that the owner incurred damages and the damages were caused by the architect's negligence. So the whole thing in explaining to the owner is that your insurance cannot be endorsed to name the architect as an additional insured on your PL policy. And unless you're prepared to pay out of your own pocket to defend the owner against a lawsuit by a third party, you can't include a defense obligation in the indemnification.
Excellent. And I think we have a couple different types of indemnity issues that might arise. So the next one being an indemnity requirement of negligence.
Yeah, we sure do. Okay. There is negligence is required. If you don't have an indemnification clause that requires the showing of negligence before the indemnification takes effect, you're essentially agreeing to liability assumed by contract. There are some exceptions to that particular policy exclusion, that's liability assumed by contract. And the exception states that if you would have been negligent anyway, then the policy would apply. So aside from the policy exclusion, what you want to do in agreeing to a contractual indemnification clause is you want every element of a cause of action for professional negligence to be reflected in this indemnity. So you're not agreeing to anything more than the law would otherwise impose on you in a negligence-based action. So there are 4 elements to a cause of action for professional negligence. And the plaintiff, probably the owner in this case, has to carry the burden of proving all 4 of those elements. The first one is that the plaintiff, the owner, has to prove that there's the standard of care, and usually that requires expert opinion testimony where the owner has to state, okay, this is the standard of care that the architect is supposed to adhere to in performing the services on this project. Then the owner also has to prove on the next element that there was a deviation from accepted standards of care. So those 2 elements establish negligence, that there was a standard and there was a breach of that standard. The third element of the cause of action is causation. And it's not just like loosey-goosey kind of cause, maybe attributed it to, but it's proximate causation. So that's a strong causal element, which is the third one. The fourth one is damages. So the owner has to prove damages too. So the appropriate, insurable, and fair indemnity has to reflect all 4 of those elements of cause of action for professional negligence. So here you see that we've deleted the defense obligation, we've deleted those predetermination nouns, we've introduced causation. So it's not like connected to, mildly related to, in whole or in part. It's caused by, and you can even put an adjective in there like proximately caused by, but it has to be strong. And then the architect's negligent performance of the services on the project, not just anything that you do on the project, but it has to be negligence.
Excellent. Thank you, Nancy. I think you just elegantly summarized about 6 months of a tort law class in law school in about 20 seconds. So very well done.
Great.
Let's talk about additional parties. Always a fun one.
Yeah, you might find in reviewing the proposed indemnification in the parties' contract that not just the owner is expected to be an indemnified party, but a whole bunch of other folks seem to want to have a contractual indemnification benefiting them and to your detriment. This could be like the owner's lenders, the owner's consultants, the construction contractor, and you have to really be careful when you see agents in there, because agents could be, they could just be anybody. So what you want to do is agree to a contractual indemnification if it meets all the requirements that we've talked about in the last 2 slides. But you only give your contractual indemnification to the party with whom you're contracting. So in this case, we're assuming that that's the owner. Any other folks here, like that you see here in red font, if any of these folks feel that they've been damaged by the architect's services, they can pursue a negligence-based action against the architect. They don't need the benefit of a contractual indemnification. So be mindful of this. Even though your commercial general liability policy, your auto policy can be endorsed to identify these folks as additional insureds, and they would get the benefit of a defense and the contractual indemnification. You cannot do this on your professional liability policy, and so this should not appear as a indemnification clause in the owner-architect agreement.
Excellent. That's incredibly complicated, and you made it very simple for everyone, so thank you.
Sure.
The next one, number 6, is prevailing parties clause. And this one, I will say, like back when I was practicing, the prevailing parties clause always gave me some pause, and it needs to be worded carefully, you know, obviously to be enforceable. It sort of goes against other traditional notions. So I was wondering, you know, perhaps, Nancy, if you could maybe go into a little bit about prevailing parties, why they're good, why they might not be good, and how to negotiate them.
Yeah. Back in the 1970s, when there was a big explosion of litigation, parties thought that putting a prevailing party clause in the contract would tend to deter litigation. But after what, 40 years, 50 years of this, we figured out that this prevailing party clause does not deter litigation. People are gung-ho to sue no matter what. So I have worries about this prevailing party clause, and it creates a lot of problems. Number one, an insurance coverage problem. A prevailing party clause is, in theory, an equitable remedy. And it is something that is liability assumed by contract. So if you're looking at it as equitable relief, you look to your policy definition of damages and you see that equitable remedies are not included in the definition of damages. So you have a problem at that end. and you see prevailing party, well, really isn't how we pay attorney's fees traditionally in the United States in litigation. So this is liability assumed by contract. So that's another policy exclusion. So this clause that originated in the 1970s in order to decrease the amount of litigation, it's going to get more litigation and probably over coverage litigation. So staunch it at the get-go and delete prevailing party clauses. There also create real problems in interpreting prevailing party clause. So like imagine a scenario that you are negotiating possibly a settlement with the owner, and you make an offer, like a formidable offer to settle the case, and this is on the eve of trial. Well, let's say that the owner rejects your offer and the parties go to trial. The owner wins, but the amount that the jury awards the owner is much less than the amount that you had offered on the eve of trial. So if it were me, I'd be like, yay, I won. But in theory, I'd still be losing, but I don't know. How would you interpret who the prevailing party was? If the owner could have received a lot more if he had accepted my offer on the eve of trial, does that make him still the prevailing party? I don't know. So I can imagine maybe there's some post-trial motions over that. Maybe there's more litigation as to how to even interpret who the prevailing party is. So I say at the get-go, aside from all the uninsurability problems associated with this clause, aside from the ambiguity, it's inconsistent with how we resolve disputes here in the United States. In the United States, absent some kind of statute or regulation allowing one party to recover attorney's fees, each party in the United States in our traditional system pays their own weight with their attorneys. So let's keep it that way and delete that clause.
That's a great summary. And I would imagine all the architects, the non-lawyers watching are rolling their eyes saying, leave it up to some lawyers to debate the definition of the word prevailing for months and months and months, but somehow we will. So let's go on to number 7, which is responsibility for job site safety. And this is actually, we've gotten a lot of questions about this particular clause and this issue, especially over the last couple of years with COVID and some other issues. So Andy, would you maybe walk us through this topic and how it comes up and how to negotiate it?
Sure. Hopefully this one's a little bit simpler. I'm hesitant to use the word universally accepted in the industry as contractor responsibilities, but even in some really bad owner-generated agreements, we usually see the responsibility for job site safety, as well as the means and methods of construction, as the sole responsibility of the contractor. That exists in any industry standard form agreement as well. But that doesn't mean that an owner may not try to tweak your responsibilities. And again, like I referred to earlier, as far as the construction phase services section, they may put in a sentence such as this, that you're going to report safety hazards at the job site to the owner. Well, that's stepping over the line of what your normal site observation would be, and puts you in a position where you've actually got responsibility to look for safety hazards and report them to the owner. And that, again, as Nancy referred to earlier, as far as a contractually assumed liability, contrary to common law, puts you in an uninsurable situation. You do have a moral duty, just as a person, and particularly as a design professional. If you see a situation where a worker is in imminent danger, an example is for like site work, if there's a big trench that's been excavated and they're laying some underground sewer, and it's raining out and there's no bracing on the trench, and you've got a bunch of workers down there, and you see mud flowing into into the thing, you have kind of a moral obligation to go over to the construction site superintendent and say, hey, there's something going on over here. It's not my responsibility, but job site safety is yours. You better take a look at that. And that's about, that is an important thing to be aware of. But as far as actually reporting on and creating safety plans and any of that, you don't want any responsibility in that regard. So you want to just strike that. On our next slide, Nancy has edited a clause where an owner was trying to increase the architect's responsibilities. And really what your only responsibility should be is for when your employees are on the job site to comply with the safety plans that the contractor has established. So if the contractor says you're going to wear a hard hat, you're going to wear safety glasses, you're going to wear steel-toed shoes, you need to do that. Now, that's good practice anyway, and you may have that established as far as your employee practices. When your people are out on a job site, they're wearing the appropriate PPE, which can include a hard hat and safety goggles and appropriate shoes. And now you mentioned, Jim, earlier, the issue of COVID and, masks and sanitation and all that. And contractors, really dialed up their level of attention to this. And again, as an architect visiting a job site, you have to comply with those standards and plans that the contractor has established. And in fact, your company may even establish your own standards. And whether the contractor has requirements for PPE or not, you want your employees to be safe on the job site and for their own protection, but it's only their own protection. They don't have any duty regarding the construction workers or anything like that. So, this was an attempt to, modify a bad clause to really put it within the context of something that could be reasonably your professional responsibility.
Sure, that makes total sense. And it sort of goes back to something, Andy, that you said earlier, and Nancy, which is just, allowing the contract to reflect what, a reasonable apportionment of risk and responsibilities, and something like this seems to really do just that. All right, so number 8 is copyright and licenses. And this is one that might not get a lot of play during the negotiation process, particularly maybe from an outside firm or somebody who might not understand the nuances of how design firms in 2021 really perform their work. But Andy, why don't you sort of explain what the pitfalls can be here and how to avoid those?
Well, the basic issue is that, drawing specifications, reports, and other documents that you produce as an architect, as well as your digital files, are instruments of professional service, and they're not products. And so that relates to the standard of care. But what's really important that as an architect, you have fundamental rights in U.S. copyright law to the intellectual property that you produce. Owners often insist on ownership or having an unlimited license to use the instruments of service, and you should resist relinquishing ownership and instead provide the owner a limited license for the client's specific needs for the instruments of service which you produce, which reasonably include construction, occupancy, maintenance, and reference for future revisions to the project, not the rights to reuse your documents on other projects. And these license rights are defined in Article 7 of the B101. And again, it's relatively complex in terms of the legal issues. So again, in the concept of every word matters, be really careful when these get edited. But these bullet points here are really important. First of all, we feel that you should never extend a license, or if you're going to agree to transfer document ownership in part, without payment in full. You need to be paid before you're transferring your license. You should avoid this phrase, words make for hire, works made for hire. This basically means that as soon as you put pen to paper or your plotter starts plotting out or you've generated a digital file, that means the minute you do that, the owner owns those documents and those files. And that's just contrary to what I mentioned earlier about what your basic rights are in U.S. copyright law. So avoid that. If you do transfer partial ownership or transfer this license, you should obtain an indemnification from the owner for any claim or liability that arises relative to the use of the documents that are contrary to this clause, any improper reuse or just unintended use after you've transferred it. When you do make a transfer of ownership, if you decide to do that under the, with these indemnities and everything else, make sure you retain ownership of your firm's standards, your standard details, schedule specifications not unique to the project. And we're starting to see some of that kind of language even from owners, is they're trying to get these broader rights. And then finally, with electronic transfer of your files, and we've been talking about this for over 30 years with CAD, and AI has been really focused on this for a long time now on BIM. You need to have a properly drafted electronic transfer agreement. And good opportunity for Jimmy to tell us what's happening with Documents Committee as far as the updates of this. But again, really, really important, particularly to protect your rights in this regard, and to make sure you're paid, and to make sure these documents and files are not misused.
Absolutely, and a really timely and important topic, especially as we keep moving the industry forward toward more, building information modeling and digital data being transferred and shared among the parties. And Andy, you read my mind, because I did just want to say briefly that the BIM exhibits, as everyone probably knows, AI contracts are updated usually every 10 years, and the BIM exhibits are 2013 documents. So they are set to come up for renewal soon, and we've been working on them. So keep an eye out for updated BIM exhibits and kind of a new format, new structure for how that's going to work to adapt to the industry, because so much has changed since 2013 in this area specifically. I mean, a lot's changed everywhere, but with respect to BIM, I mean, in 2013, we were all walking around with flip phones, even if we had one. So, a lot has changed for sure. And so with the couple of minutes we have left, let's go to our 9th and final topic. Nancy, why don't you bring us home talking about guarantees and warranties?
Okay, I'm going to make this really quick. The number 9 on the no-go 9, because we're bumping up with only 3 minutes left. But warranties and guarantees, by definition, making a certification or guaranteeing, it means that you are assuring the total accuracy of something. And this is inconsistent with the standard of care, with what we've been talking about all along. If you are making this kind of certification, it's not insurable. You will be saying something is true or correct or perfect when you might not have firsthand knowledge of it. You can certify to facts that you know firsthand, but something like the architect certifying that this building complies with all ADA requirements, or that the construction was conforms strictly to your design, that's not something that you could ever have firsthand knowledge of or legal interpretation of. So the best thing to do is that you delete these kind of express warranties and guarantees. And I just want to make one more point about the word insure. So unless we're talking about like a nutritional drink, I resist letting the word insure appear in my contracts, because insure means guarantee, and you don't want to insure anything unless you're having firsthand knowledge of it.
And Nancy, you're talking about insure that starts with the letter E, right?
E or I, yes.
Okay. Interesting.
Yes,
all right.
But insure. Many times people, instead of saying, I want to confirm this or I'll include this, people tend to resort to the word insure, not realizing that it's an express guarantee. And so unless you're going to guarantee that, pick a different action word.
Great advice for sure. I will ensure to use that next time.
No.
So if you do want to learn more, this is some contact information, websites. We do have a YouTube channel with some other videos, and we have some telephone numbers up on your screen. You'll get a copy of these slides, so you can use these to contact us if you have follow-up questions or want additional information. And I will say before I close this out, thank you everyone for attending, and thank you especially to Andy and Nancy for taking the time to walk us through the No-Go 9. And thank you everybody, and have a great rest of the day.
Bye, everyone. It was fun.